All rise. All rise. Greetings to everyone present here. Welcome to late Shri Abhay Bharadwaj Memorial National Moot Court Competition 2022. Honorable judges, dear participants and the enthusiastic audience. Greetings to everyone. We are the court masters for this final round. Shri Abhay Bharadwaj Memorial. Honorable judges, the TC77 is the counsel for the petitioner, whereas TC76 is representing the counsel for respondent. I request the teams to kindly adhere to the time limits that they have given us for the purpose of oral submissions. Is the counsel for the petitioner, whereas TC76 is representing the counsel for respondent. I request the teams to kindly adhere to the time limits that they have given us for the purpose of oral submissions. Counsel for the petitioner, whereas TC76 is representing the counsel for Honorable Sir, 77 is representing the counsel for petitioners, whereas 76 is representing the counsel for respondents. Honorable Sir, 77 is representing the counsel for petitioners, whereas 76 is representing the counsel for respondents. If there are no further queries, with the due permission of the honorable judges, can I call the Speaker 1 of the Counsel for Petitioners? Speaker 1. Permission. If there are no further queries, with the due permission of the honorable judges, can I call the Speaker 1 of the Counsel for Petitioners? Speaker
The Council seeks permission to submit the complaint.
If there are no further queries, with the due permission of the honorable judges, can I call the Speaker 1 of the Counsel for Petitioners?
The Council seeks extending my warmest greeting to honorable judges. The council seeks permission to address collectively as honorable bench and individually as the lordships. In this instant case, honorable bench, I, counsel from the side petitioner, will be dealing with issue number 1 and will be taking 20 minutes for my arguments, and my co-counsel will be dealing with issue number 2 and will be taking 27 minutes. This instant case, honorable bench, for now the council seeks permission to elaborate on the jurisdiction of this instant case. And my co-counsel will be dealing with issue number 2. Much obliged, honorable bench. The counsel from the side petitioner has approached Supreme Court of Cloud 9 under Article 32 of the Constitution of Cloud 9. Would the bench appreciate the briefing of statement of facts? So the term secularism was included as a part of preamble of Constitution of Cloud 9 in 2000. On this, several states has passed law prohibiting the religious conversion. Efforts were made to enact this law at a national level, but could not get sufficient support in the Parliament of Cloud 9. So the President in 2022 promulgated VVDSPA, that is Vidhi Viruddha Dharma Samparivartan Pratishedh Adhyadesh 2022 under Article 123 of Constitution of Cloud 9. Under this, it prohibits one person from converting the religion of another person. It also empowers courts to void any such type of marriage, and it also states that the burden of proof in this instant case will be shifted to the religious minorities. Did not argue well with the laws as they were already suffering with the onslaught of right-wing presidency. To raise their voice against unfair treatment, several protesters came on the roads against the scheme of Cloud 9. During this protest, honorable bench, Supreme Court, Suman was called by the Law Enforcement Agency and the trial court upon the request of the directed Suman to access his email ID and further allowed police for the polygraph test. The High Court further approved the polygraph test. Suman agreed by the decision of High Court, moved to Supreme Court under Article 32, stating that any direction to reveal password to unlock phone would amount to testimonial compensation that is barred in Article 20, Clause 3. On the other hand, at the same time, criminal justice and police accountability on the behalf of the students of Marwari University has filed a PIL before Supreme Court on the constitutionality of Section GG of Cloud 9 2022. Now, if the honorable bench is specified from the facts of the cases, the council seeks permission to move on to the issue number 1. University has filed a PIL before Supreme Court on the constitutionality of Section GG of Cloud 9 2022. Now, if
what do you say on locus?
Yes, Your Lordship.
Locus of the petitioner, because this is PIL.
Yes, sir. So since we are council, we have approached the Supreme Court under Article 32 under public interest litigation. So I am the council who is representing the people who are not valid or who are not the law. So I will be representing you.
See, this is maybe that you have challenged the constitutional validity, but it's a in fact a dispute between two individuals, intercaste marriage or interreligious marriage. Correct? Then who can be said to be the aggrieved person?
Your Lordship, the reason why council is challenging the constitutionality of this particular reverse onus under clause section GG is because this law is infringing. First of all, this law is violating basic fundamental rights that is given to a citizen. Plus, the reverse onus itself that is started under this section is not constitutionally valid. That is why the council, on the behalf of petitioner, is filing a PIL under Article 32 of the Constitution of
Who can file the PIL?
Your Lordship, anyone who feels that a particular law is harming a society or a citizen of a state is eligible to file a PIL. Now the council seeks permission to move on to the issue number 1. Much obliged, Your Honourable Bench. The first issue is regarding the constitutionality of reverse onus, that is practically section GG of Cloud 9, Vidhi Virodha Dharma Samparivartan, Pratisheth Adhyasni is constitutionally invalid. For this, I would like to bring out four-fold test that has been given in Sheikh Muttakar versus State of Maharashtra, that is given in page number 1 of our Moot memorial and page number 3 of our Moot compendium. The four-fold test, the first criteria being the state is required to prove the basic or essential facts constituting a crime. In Noor Aga Khan versus State of Punjab, that is given on page number 7, page number 2 of our Moot memorial, plus page number 2 of our Moot compendium, it was held that guilt only arises when prosecution proves certain foundational facts will shift the burden of proof to the accused. Now, in this case, Honorable Bench, Cloud 19 law does not satisfy this basic foundational facts. The foundational fact that there has been a conversion is not sufficient to prove the probable connection in this regard, Honorable Bench. Now, in this case, Honorable Bench, establishing the non-consensual nature cannot suffice to establish the probable connection between the facts and the criminalized act of this law, Honorable Bench. As there can be the cases where the conversion has been done with the consent of the victim. So the first criteria, the state of Cloud 9 is failing to prove the first basic essential. The second basic essential means the burden imposes an unreasonable standard of proving negative facts of the victim. So P. Krishna Lal versus Government of Kerala, that is given in paragraph 13, page number 4. The second basic essential means the burden imposes an unreasonable standard of proving negative facts of the victim. So P. Krishna Lal versus Government of Kerala, that is given in paragraph 13, page number 4. The second basic essential means the burden in PM Krishna Lal versus Government of Kerala, that is given on paragraph 13, page number 4 of our Moot memorial and page number 4 of our Moot compendium, the Apex Court said that burden of proof cannot be allowed when presumption is raised in relation to the proof of negative facts. Now, in this case, Honorable Bench, the ordinance of Cloud 9 criminalizes conversion via misrepresentation, force, undue influence, coercion, allurement, or by any fraudulent means that is given on second page of second paragraph of Moot proposition. It is also given in the preamble. Now, Honorable Bench, negative facts proved by the accused is that no allurement has taken place. Now, broad terms like allurement and temptation require an analysis of mind of the victim at the commission of the crime, Honorable Bench. It is unthinkable and it is very difficult to explain that at what point and up to what extent the other party has felt allured or the other party has been tempted, Honorable Bench. It is very difficult to disapprove the subjective feeling of allurement once alleged by the prosecution. The state of Cloud 9 could have put an unreasonable burden on accused and thus make it harder for accused to prove this innocence even if it is filled with malafide intention. Going on to my third constructive, Honorable Bench, that the burden of proof should amount to the harmful purpose. Now, in Sheikh Zaid Muttakar versus State of Maharashtra, that is given on paragraph 18 and page number 4 of our Moot memorial, it was held that knowledge or mens rea is imputed on accused where possession leads to the presumption of harmful purpose. Now, Honorable Bench, merely proving basic foundational facts that religious conversion took place doesn't lead to the furtherance of harmful purpose, Honorable Bench. There can be multiple cases where consent has been taken, where religious conversion has been done with the consent of victim. To strengthen my point, the council draws attention on section PP, that is given on the first paragraph, second page of the Moot proposition. It says that any person by religion or even via marriage can launch FIR against this religious conversion. Now, Honorable Bench, even if someone has consented for the religious conversion, anyone who is either connected by blood or by via marriage can launch the FIR and can launch the FIR even if this marriage was not forceful or not leading to a harmful purpose, Honorable Bench.
We will suggest one thing to you. You believe in bullet train? Don't worry, take your time. mind. When you say, just for future guidance, we are telling you. When you say page number 2, correct? Then you should give us the opportunity, correct, to turn to page 2. You know you have already turned to page 2. We have not turned. So it will be absolutely bulleted. Okay? For future, you are doing very well. Continue. When you say page number 2.
Seeks apology.
Okay,
Yeah, so in second page of first paragraph of the proposition, it is written that any person by birth or via marriage can lodge FIR against lodge FIR. Now, even if the victim has given his or her consent under this honorable bench, anyone who is maybe not agreed or not in the favor of this marriage can lodge FIR, and now the burden of proof will be shifted on the accused to prove that this marriage is not illegal or not unforeseeable, Your Lordship. The standard of imputing knowledge on the accused is not satisfied in the present case. Since law promulgated failed to satisfy the basic contention of Cloud 9, the reverse onus crafted in section GG of Vidhi Viruddha Dharma Samparivartan Pratisheth Adhyadesh is constitutionally invalid. Now the
Counsel, one question I had is that who is the best person to prove this? Is it not the accused? Why would you want the prosecution to prove this point?
Your Lordship, the council believes that reverse onus in any case should be applied when the basic contention of reverse onus is fulfilled. The first contention being that is given in Noor Aga Khan versus State of Punjab. It said that before shifting the burden of proof to any accused, it is the responsibility of state to give the to establish the essential facts that will make evident that the burden of proof is that will make evident that the accused is guilty, and now burden of proof will be on the accused to
one question.
Yes, Your Lordship.
Under the Evidence Act, initial burden is upon the prosecution. You are right, absolutely right. Correct? But the moment in the FIR or the complaint it is alleged, correct, that this was the marriage which was by allurement or illegal, correct, then immediately the onus will be shifting upon the accused to prove that no, it was not by allurement. So it's a question of shifting the onus. First, that will be allegation. Correct? Thereafter, correct, that the moment allegation is there, correct, what in the complaint, only allegation will be there. They will not be in a position to prove, correct? You have to disprove, correct, by reading the evidence, by examining the victim, correct, that yes, that it was my concern, there was no allurement. Therefore, correct, the onus is thereafter upon the accused.
Yes, Your Lordship. To answer your question, Your Lordship, I would like to take the reference of the cases like rape or dowry death. What happens in that case, Your Lordship? The basic credential why the burden of proof is shifted to the accused, specifically in the case of rape that is given on section 114A of Indian Evidence Act. It says that once the victim has proved that he or she has not given the consent, immediately the burden of proof will be shifted to the accused to prove.
Sorry, 1 minute. Victim has not to prove it. Victim is not the complainant. Complainant is maybe, correct, some other person or the parents also, it can be there. But victim can be examined, victim can be complainant also. Sorry, see, victim has not to prove. So victim can be complainant also.
Yes, Your Lordship.
That I was lured or my concern was by misrepresentation, by fraud, everything. Correct? The one C step is the witness box. Second says, correct? Thereafter the burden will be upon the accused.
Yes, Your Lordship. Yes. So what is the difference between this instant case and the case of rape, Your Lordship? Your Lordship, once the prosecution side has proved or the victim has proved that my consent was not there, immediately the burden of shift is proved to the is shifted to the accused. But in his instant case, there can be chances, and which I have case where the victim with the consent of the victim can conversion has been happened. Then also, if anyone who's from that family, his family, can lodge FIR. This is a very loophole that is given under Section PP on this law. Since even after the consent, even everything is done with the consciousness and consent of the victim, then also the burden of proof is shifting to the accused. This is very unfair for the
What is the standard of proof? Is it beyond reasonable doubt or preponderance of probability?
Your Lordship, for reverse owners, the council believes it's preponderance of probability.
So what is the problem? Because it is not beyond reasonable doubt.
Your Lordship, the problem being in the instant case is the two arguments which I gave earlier. Firstly, the state has to believe the basic foundational facts, Your Lordship. Mere conversion, we are saying that conversion has been happened. It does not mean that the conversion which happens is illegal or is void or unforceful. They have to give up the state. You have to prove the state has to prove that and establish a proper foundational facts that this conversion which happened is illegal. Basic saying that there has been a religious conversion doesn't amount to the amount making my client.
We got your point, correct? We got your point that the law as stands, which provides the initial burden itself to prove it is upon the accused, correct? It is contrary to the basic principle of the evidence act. We got your point. That is it. Proceed further now. You can go to the next point also.
The council seeks permission to move on to the second sub-contention.
Correct.
Much obliged, Your Lordship. The second sub-contention being that the second sub-contention being that this particular law is violating Article 14, 15, 21 and 25 of the Constitution of Cloud9. Coming to Article 14, basic contention of Article 14 is equality before law and equal protection of law and bench. Cloud9 Vidhi Viruddha Dharma Samparivartan Pratished Adyadesh 2022 is violating Article 14 and this will lead to several unfair treatments of religious minorities. As if someone wants to convert his religion, he won't be able to do that because anyone can lodge FIR and it will be very difficult for the accused to prove himself innocent. This will lead to indirect discrimination based on the religion or honorable bench. To strengthen my argument, the council seeks attention on Moot proposition page number 7, last paragraph. Here it has been mentioned that the minorities is already suffering from the onslaught of rising incidents. That means the minority is already been suffering from all the unfair treatments that is happening in the society. Now, if the state will be implementing this law, Your Lordship, this will lead to the further deterrence. Your Lordship, in the case of Loving versus Virginia, which is very similar to our instant case, Honorable Bench, which is given in page number 6, paragraph 30 of our compendium. Which is given on page number 6, paragraph 30 of our memorial and page number 7 to 10 of our compendium. Here it was held that merely because the law banned interracial marriages of all races, it does not mean that the law is equal for everyone, Your Lordship. So in this instant case, even if the state of Cloud9 is banning all the interracial marriages, it does not mean that everyone, it does not mean that the law is equal for everyone. So in this instant, Honorable Bench, the particular law is violating Article 14 of the Constitution of Cloud9. Moving to Article 21, that there is the violation of Article 21 is divided into two arguments, Your Lordship. First, right to personal liberty, and second is presumption of onus or onus of proof. That is the basic essentials of Article 21, Honorable Bench. Under right to personal liberty, in Menka Gandhi versus State of Punjab, that is given on page number 6, paragraph 32 of our Moot memorial and page number 5 of our Moot compendium, it was said state that personal liberty covers a variety of right to constitute a personal liberty of a person. In the same case, and again the same case which is similar to the case of the Cloud9 is Shafeen Jahan versus Ashokan KM, that is given on page number 7, paragraph 32 of our Moot Memorial and page number 14 of our Moot Compendium. Now in this case, Honorable Bench, if the religious conversion was happened with the consent of the victim, then also their family lodged an FIR. To this, it was held that right to marry a person is one's choice under right to privacy and personal liberty. That comes under Article 21, Honorable Bench. Under Article 21, Cloud9 is restricting people to marry with their own consent, Honorable Bench. Hence, it is violating the first basic essential, that is personal liberty of a person, that covers under Article 21. Coming on to the second basic essential is the presumption of innocence or the onus of proof, that also covers in Article 22. This law, anti-conversion law, is violating the right of presumption of innocence, Honorable Bench. Article 1 says that accused will be innocent unless and until proved by the prosecution. Now in the case of Deena versus Union of India, that is given on page number 7, paragraph 37 of our Moot Memorial and page number 11 of our Moot Compendium, it was held that weakness of petitions cannot establish the matter of fundamental right. Weakness of petition cannot establish the case for government if it involves the matter of violation of fundamental rights. The burden of proof lies on the government to prove that it is constitutional. Now in this instant case, Honorable Bench, where the council has already proved that this particular law is violating fundamental rights that is given to a citizen, Honorable Bench. So now the burden of proof is on the government to prove that this particular law is constitutional. Moving on to my last argument, Honorable Bench, that this particular law is violating Article 25 of the Constitution of Cloud9. Honorable Bench, Article 25, Clause 1 guarantees everyone the freedom of conscience and the freedom to profess religion. Cloud19 has curtailed this freedom, Honorable Bench. In case Puttaswamy versus Union of India, that is given on page number 8, paragraph 40 of our Moot Memorial and page number 12 of our Moot Compendium, it was held that right to make personal choices included right to marriage. The Constitution guarantees each individual the right to freely profess and propagate religion. Choices in the matters of marriage lie under the right of personal liberty, Honorable Bench. Cloud9, by making VVDSPA law, is not giving individual right to marry in another caste. Hence, it is violating the Article 25 of the Constitution of Cloud9.
See, there is no restriction on it doesn't infringe your right to marry the other religion, correct? What is illegal is per se conversion or conversion by force or compulsion or by misrepresentation.
Yes, Your Lordship.
What do you say on that?
Your Lordship, since even the state is not giving the proper space.
No, according to you,
yes, Your
it infringes your right to marry as per your choice.
Yes, Your Lordship.
Correct? Does it provide that no, you don't marry at all the other religion?
No, Your Lordship. But in case of anti-religious conversion, Your Lordship, if suppose take the example of just 1 minute, Your Lordship. Yes. Take the example of Salmat Ansari and others respondent versus state of UP and others. A 3-bench judgment that is given on the last page of our Moot Memorial. It is said that in this instant case, Your Lordship, a person who by her own consent marries to a person of another religion and their their parents or their acquaintance has filed FIR only because they are not in the favor of this particular marriage. Now, your lordship, the very problem in this law is we are not against this law if this law is violating illegal or forceful marriage. What we are against is against in this particular law is this is not giving the fair chance of accused to prove his innocence, your lordship. Even there are many cases, or in the cases where the law has been implemented in many states of India, your lordship, and there are many cases regarding where the conversion has been done with the consent of the victim, but since the families are not in the favor of that marriage, they filed an FIR. Now the burden of proof will be shifted to the accused to prove that the marriage is done with full consent and lawfully. That is the problem in this particular law, your lordship, and that's why we are arguing against this. If the honorable bench is well sufficed with my arguments, I would like to call my co-counsel for the second.
Thank you very much.
Much obliged, your lordship.
Just only one question.
Yes, your lordship.
When you were arguing, you were looking at this. Something is written there.
No, your lordship.
Okay.
Just I was a bit.
You done your best. Very good. Yes, counsel.
The council seeks permission to approach.
Yeah, come. You will argue on what?
Issue number 2, your lordship.
What is that?
Issue number 2 talks about the validity of direction passed to reveal the password of personal electronic possession by the trial. Your lordship, the council on behalf of appellant claims that the order passed by the honorable court is violative of Mr. Shuman's right against self-incrimination under Article 20 Clause 3. The same will be explained in my following 2 contentions, your lordship. The first contention being validity of Article 20 Clause 3 and the second contention being violation of Article 21. Coming on to my first contention, your lordship, which explains the validity of section 20 clause 3. There has to be 3 essentials fulfilled for a person to file a case under Article 20 clause 3, and the same is: number 1, to a person accused of an offence; number 2, to come against compulsion to be a witness; and number 3, against himself. And Article 20 clause 3 cannot be invoked unless all the above mentioned ingredients are sufficed. Explaining my first very essential, that is Mr. Shuman wasn't accused. In accordance with the facts, yes, your lordship.
1 minute. Just to correct yourself in future, because we are sure that you will be joining the litigation also. Correct? Whenever you challenge any particular provision, correct? Don't jump to the conclusion that the bench has read and knows the section. You have to first take us, correct? That suppose you are challenging section 20 or clause 20. First you have to take us to clause 20, correct? Thereafter you can attack clause 20.
Sure, your lordship.
There is always a presumption that bench knows everything, but that always presumption is rebuttable.
Sure, your lordship.
So please, you have to take us to section so that you can very well, say, correct, I am challenging this, correct, now let us see on this.
Yes, your
So
lordship.
it will help you in future. We are not correcting you, but we are just telling you.
The council seeks apology, your
Please, no, not apology.
The council would like to draw the attention.
What you are doing, correct, it is amazing. Your courage standing before the court, correct, and fluency, preparedness, correct. We were not even in the first year. We were not even knowing anything. Evidence we were not doing the Article 20, Article 21, Article 19, Article 14. But you are doing, all of you. We are telling you, excellent work. And credit goes to your professors and the institution. So we are just telling you, whenever you start, correct, you have to first take us, sir, let us see section 20, whatever you are saying. Thereafter you can proceed further.
Okay.
Okay.
The council would like to draw the attention of honorable judges to the Article 20 Clause 3, which says that no person accused of an offence shall be compelled to be a witness against himself.
Correct.
Now, coming on to my first very essential.
Now, what are you challenging here?
We are challenging that the order passed by the trial court to reveal the password of personal electronic possessions.
What is the order passed?
The order passed by the trial court was to have the polygraph test against Mr. Shuman, and the same order has been upheld in the High Court also.
Correct.
I have a one
You continue. I'll just ask a question, very important question.
Sure.
Huh? Yes. Yeah, come.
Coming on to my very first essential, Your Lordship, that Mr. Shuman was an accused. Now, in accordance with the facts of the case, it is clearly written that Mr. Shuman was caught by the law enforcement agencies. He was accused of enticing protests against the governmental law. In case of Selvi versus State of Karnataka, mentioned on page number 10 of our memorial, paragraph number 48, also mentioned on page number 16 of our Moot compendium, the court was of the view that right against Article 20 Clause 3 becomes available when a person has been formally accused. Now, as Mr. Shuman was accused and arrested, so the very first essential is sufficed. Now, coming on to my second essential be, Mr. Shuman was compelled to be a witness. Now, Your Lordship, compulsion is an essential ingredient of the clause. Compulsion may be of many forms, either mental or physical, and mental compulsion takes place when the mind of the accused has been so conditioned. Now, in the case of Nandini Satpathy versus P.L. Dani, mentioned on page number 10 of our Moot memorial, citation number 30, and also on page number 17 of our Moot compendium, it was observed by the apex court that it is the evidence procedure not merely by physical threats or violence but also by psychic torture are compelling testimony. It was held that any mode of pressure, subtle or crude, mental or physical, direct or indirect, but sufficiently substantial applied by the police to obtain information from an accused are strongly suggestive of guilt or compulsion. Now, Your Lordship, in the instant case, we can see that when Mr. Shuman tried to oppose, mentioned on page number 8, line number, Your Lordship, line number 4 and 5, which states that firstly, Shuman has refused to cooperate. Now, we can see when Mr. Shuman tried to oppose, the police went to the court to order for a polygraph test in the court, and without giving him any opportunity to be heard, the court ordered to have the polygraph test. It is mentioned on page number 8, line number 10, which states that according to Mr. Shuman, the orders were passed without giving him any opportunity to be heard and without considering if he had indeed consented to undergoing such test.
One question.
Yes, Your Lordship.
Very complex question. Correct? It will test your IQ.
Okay.
Correct? When you are talking about consent,
Yes,
Huh?
Lordships.
which accused will give the consent? That I am ready for polygraph test or I am ready for narco test. A hardcore criminal will never give his consent. So at no point of time, correct, it can be done, or it can be said to be violative article, the right, the principle of natural justice.
Yes, Your Lordship.
You tell us any accused who has really committed offence and hardcore criminal will give the consent. No, I am ready. Unless he is sure and unless he says I am innocent and that okay, take my polygraph, I have no difficulty.
Your Lordship, in the instant case, the counsel would like to highlight that it was the allegation of police and the police fought Mr. Shuman. They, according to their understanding, they thought that he was the accused.
No, we are not on that. We are on that the order which is passed is without hearing and without consent.
Yes, Your Lordship.
We are on that.
Your Lordship.
Which is a very complex question. There is a decision of the Supreme Court also.
Yes,
Correct? There is a decision of Gujarat High Court also. I'll tell you subsequently.
Sure, Your Lordships. Your Lordships, for this the council would like to cite the case of Selvi versus State of Karnataka, mentioned on page number 11, citation number 32 of our memorial, and page number 18 of our compendium, which says that the apex court observed that polygraph examinations should be treated as personal testimony, since they are a means of impairing personal knowledge about relevant facts, and the result obtained through the involuntary administration of the above test comes within the scope of testimonial compulsion, thereby attracting the protection shield against Article 20 Clause 3. Your Lordship, as the council has already stated that the polygraph test were ordered by the trial court without giving him any opportunity to be heard, violating his very fundamental right.
What opportunity? You tell us. What type of opportunity?
The opportunity to represent himself and...
No, represent is okay, correct? But after opportunity, what is to be given? Opportunity for the purpose of consent?
The opportunity to listen, to listen my client that what actually he has done.
No, that is at the time of trial. What he has actually done or not.
Yes, Your Lordship.
At present, we are concerned with the only polygraph test.
Yes, Your Lordship.
Maybe in a polygraph test or narco analysis test, both are virtually on the same footing.
Yes, Your Lordship.
Correct? Then what type of opportunity? And you are alleging because opportunity is not given means principle of natural justice is violated.
Yes, Your Lordship. Your Lordship, as per the given facts of the case, here the opportunity was not given to be heard properly. Like he was not
properly given or not given at all.
He was not given any opportunity to be heard.
There is a distinction difference between opportunity not given and proper opportunity not given.
Yes, Your Lordship.
Because proper opportunity depends upon the satisfaction of the client and the advocate.
Yes, Your Lordship.
Yes, come on.
Yes, Your Lordship. According to the Moot proposition, page number 8, line number 11, it states that according to Schumann, the orders were passed without ever giving him an opportunity to be heard and without considering if he had indeed consented to such undergoing test. Now here, Your Lordship, there was the council on behalf of petitioner believes that there was not such any emergency for the police or the trial court to order him to go for a polygraph test, as it was not that the police was not sure that whether Mr. Schumann had something in this phone or not. So they cannot order him to unlock his phone and infringe his right to privacy.
But there is distinction between the two. One is that the polygraph test was only for giving the password, not for any confession. So how it was forcing a person to be a witness against himself? It was only for the password, not for anything that the person has done any crime or any offense. So how do you distinguish between giving of password and giving a confession?
Your Lordship, in the instance case, the trial could order Mr. Schumann to undergo polygraph test so that it could confirm the email account password and his mobile phone password, for which the trial court and the police observed that Mr. Schumann had been lying. It was their contention that Mr. Schumann had been lying, and for which they went to the trial court to ask for the polygraph test to be conducted.
But what is the option? If he's not giving password, then how do you get the password of it?
Your Lordships, it is already mentioned in the Moot proposition, page number 8, line number 5, that earlier when Mr. Schumann refused to cooperate, we can see after that he complied with the authorities. He consented to give his password. Now further, when the police ordered for the polygraph test, we can see that his right was violating. So my client appeared before the trial court and against this contention.
No, she readily agreed, no, for giving the password.
Your Lordship, it appears that Mr. Schumann has complied.
Then there was no reason for polygraph test. Once the password was given, the cause for polygraph test was not there.
Yes, Your Lordship. The council on behalf of petitioner indeed is claiming that the polygraph test was compelling my client to be a witness against himself. That's what.
What? Only for the purpose of password, no?
Yes, for the password as for the polygraph test.
Now we'll give one example. When the polygraph test, correct, or the narco analysis is required. In a given case, it may happen that triple murder has taken place. And no eyewitness, nothing. Investigating agency has tried its best to find out the truth, but they were not they were clueless. In that case, correct, only with a view to in furtherance of the investigation, correct, the application was given for polygraph test or so and so. Suppose the particular statement which is coming out of polygraph test or the narcosis, it is used, correct, that particular statement, then it can be said to be violated Article 20, 21 and 22 because it is used against himself, correct. But correct, if it is not used at all, but that whatever he has stated, correct, on that line the investigating agency may proceed further with the investigation and ultimately find out the truth. Does it sometimes not violate the right of the investigating agency also?
No, Your Lordships. The council on behalf of petitioner claimed that in the instant case, Chuman was caught by the law enforcement agencies and he was accused of enticing protest.
No, caught is okay. Caught is not the proof of guilt.
Yes, Your Lordship.
Ultimately, even after the arrest also, the investigating agency has to prove,
yes, Your
correct, that you are the guilty.
Yes, Your Lordship.
Correct. It is a circumstantial evidence, then the complete chain of events, correct, that. What do you say, whether it violates the right of the investigating or it is in furtherance of the investigation or not?
No, Your Lordship, the council on behalf of petitioner believes that it is
so
not...
what should the investigating agency do thereafter?
Your Lordship, firstly, the investigating agency should try to take the consent of the accused.
Which that is my first question.
Yes.
Which accused will give the consent?
Your Lord, yes, Your Lordship.
I have never seen any accused who has in fact committed the offence, correct, will give any consent against himself.
Yes, Your Lordship.
And invite the trouble for himself.
Yes, Your Lordship. But no one would...
It's a very complex question, correct? Just we are testing a very complex question. And in fact, I was an author to that judgment here in Gujarat High Court. I passed an order of narco analysis. I considered everything. All these submissions were considered by me. Article 21, Article 22, right of the investigating agency. It is in furtherance of the investigation. And thereafter, per se, it is used. It can be said to be violative Article 22. But if it is not used, but it is used for the purpose of, suppose in the narco analysis test, correct, he gives some clues.
Yes,
correct, and on that basis the investigation has begun, and ultimately the investigating find out the truth. Can it be said per se, correct, initial stage it is violated Article 22? Of course, correct, my judgment was set aside by the Supreme Court. I am saying so. But still I believe, correct, that it requires reconsider because of the fact that now the criminals, correct, who are committing the offences, correct, they first of all plan it. And thereafter now, so if in white collar, you see criminals, correct, pre-planned criminals, correct, all these things ultimately everybody has to consider.
Yes,
because right of the investigating agency is also in favor, it is in the interest of the society at large.
Yes, Your Lordship.
Because the rule of law is to be maintained by the investigating agency. Then next.
The council seeks permission to further continue the arguments.
Yes.
Your Lordship, coming on to my second sub-contention, being that the polygraph test is a violation of Article 20 Clause 3 and does not come under the ambit of bodily samples. Now, as already stated, Your Lordship, in the case of Selvi versus State of Karnataka, mentioned on page number 11, citation number 32 of our Moot memorial, it states that the apex could observe the polygraph examination should be treated as personal testimony, since they are means of impairing knowledge. Now, also, Your Lordship, as per the National Human Rights Commission guidelines for the administration of polygraph polygraph test on the accused in the year 2000, the court was of the view that these guidelines should be strictly adhered to. And in this, the very first guideline was that no lie detector test should be administered except on the basis of the consent of the accused. Now, as Mr. Shuman was not allowed even a fair chance of hearing, and without hearing whether or not he gave consent to have the polygraph test, the trial court ordered to have him the polygraph test, on which violates the National Human Rights Commission's guideline. It also violates the basic maxim of audi alteram patum, which means that they let the other side be heard as well. Now,
what would be his defense if the Honorable High Court says that you are heard now? You were not heard before the trial court.
Yes, Your Lordship.
So what would have been his defense? If he's heard and then the Honorable High Court decides that was this order violative of principles of natural justice or not?
Yes, Your Lordship.
Or one another thing, alternatively. Suppose High Court sets aside that order on the ground that it is in violation of principle of natural justice and remands the matter back to the magistrate.
Yes, Your Lordship.
Correct? And opportunity is given.
Yes, Your Lordship.
What will be your defense? That is
The defense would be the counsel on behalf of petitioner would explain that why Mr. Shuman's food should not be alleged and should not be alleged and should not be compelled to unlock his smartphone and grant access to his email accounts. If he is given the chance to be properly heard at the trial court level itself, the counsel on behalf of petitioner would be
how the accused can say, correct, it should not be unlocked.
Yes, Your Lordship.
How the accused can say that it should not be unlocked?
Your Lordship, the counsel
It will be asking an investigating agency not to investigate.
No, Your Lordship, the counsel would prove that why his phone should not be unlocked.
Why?
Yes, Your Lordship. He would prove that he was not involved in the protest and he was not involved in enticing the violence against the state. So he would prove by the mere facts that how the situations made him accused and the police officers arrested him.
Okay, we got your point that it was without hearing you and therefore it is against the natural justice, it is against the human rights
Yes, Your Lordship.
ruling, correct?
Yes.
And it affects your right under Article 22.
22, yes, Your Lordship. Now,
20, yeah.
yes,
I had one question.
Yes,
That,
Your Lordship.
now it's electronic evidence, right? So is it same at par with documentary evidence? Is the Evidence Act amended after the Information Technology Act?
No, Your Lordship. The counsel on behalf of petitioner believes that it was not amended after. And the counsel, however, is not acknowledged of the.
No, you can very well argue that suppose without your assistance, without polygraphy test, they have opened it, correct? And they have used it, correct? In that case, it can be considered as electronic evidence. Now, electronic evidence and the documentary evidence virtually are at par under the Evidence Act.
Yes, sir.
Evidence Act is also amended also now,
Okay.
correct? So you can consider from that angle.
Okay. Now coming on to my second contention, being that this order is also violative of Article 21 of the Constitution. There is a violation of Article 21, and the Council would prove the same in following two contentions. First, it violates the right of a citizen to have a free and fair trial. Number two, this article violates the right to privacy of a person. Now, Your Lordship, in the case of Muhammad Hussain Zulfikar Ali versus the State Government of NCT Delhi, mentioned on page number 14 of our Moot Memorial, citation number 38, the apex court was of the view that every person has a right to a free and fair trial by the competent court in the spirit of the right to life and liberty. Thus, the right to a fair trial by the virtue of fundamental right cannot be refused by any person. Here, according to the facts of the case, Your Lordship, Mr. Shuman was not provided with the opportunity to explain why his phone should not be seized and that he does not want to give the polygraph test and the reasons for the same. The trial court gave the verdict without giving Mr. Shuman a fair chance to explain himself there. Now, coming on to my second contention, being that the verdict of the court is in the violation of the right to privacy. In this case, Your Lordship, Mr. Shuman has his personal phone. So he has put a lock system on it. He does not want anyone to infringe in his private space, and does not want. But the police officers not only took his phone, but also they filed an application in the trial court to order him to unlock his phone. Now, not only the police asked for the orders to unlock the phone, but also ordered to have the polygraph test, which Mr. Shuman did not give consent for. Now, Your Lordship, as there was also no need for the phone for the greater public good, instead of self-incriminating Mr. Shuman himself, as there was not any circumstances shown where Mr. Shuman's phone and polygraph test would lead to a greater public good and security. Therefore, this would lead to breach of Mr. Shuman's private space, and there is no explanation provided for that, that it is violative of right to privacy. Now, as per the arguments presented, Your Lordship, it is violating the basic fundamental essentials of that is the right of privacy, the right of personal liberty, and the right to have a free and fair trial of Mr. Shuman under Article 21. Therefore, the verdict is infringing Article 21 of the Constitution and should be struck down. Now, if the Honourable Bench is sufficed with the arguments, the Council would like to proceed further with the prayer. Now, wherefore, in the lights of the facts presented, arguments advanced, issues raised, and authorities cited, the Council, on behalf of the petitioner, humbly pray before this Honourable Court that it may be pleased to adjudge and declare that the constitutionality of the reverse onus clause drafted in section GG of Cloud 9 Vidhi Viruddha Dharma Samparivartan Pratishid Adhyadesh is unconstitutional and should be revoked. Number 2, the validity of the direction passed to reveal the password of personal electronic possessions is violative of the principle of self-incrimination under Article 20 Clause 3, and the High Court judgment and the High Court order should be overruled to pass the password of the personal electronic possession and to have the polygraph test, and pass any order, direction or relief that it may deem fit in the best interest of justice, equity and good conscience. For this act of kindness, the Council, on behalf of petitioner, shall humbly bound forever pray. Thank you, Your Lordship.
I have one last question before.
Yes, Your Lordship.
Can I set aside the High Court order under Article 32?
Yes, sir. Could you repeat your question, Lordship?
Can we set aside the High Court order under Article 32,
Yes, Your
or
Lordship.
you have to file petition under Article 136?
Your Lordship, the Council believes that the Honourable Supreme Court can set aside the order of the High Court under Article 32.
32 also, you will.
To all figures.
Thank you.
Thank you very much, Your Lordship.
Thank you. Very good.
With the due permission of the Honourable Bench, can I call the Speaker 1 of the Council for respondent?
Yeah.
Speaker 1.
Good afternoon to the Honourable Bench. Council seeks permission to submit the compendium. If it may please, the Council seeks permission to address the bench, Your Lordship.
One thing, first thing, just advice, correct? When the bench is constituted of 5 judges, you should prepare and give 5 sets. Because this, you are addressing the 5 judges. Each may have a different views and each may ultimately, correct, take an own views. It is not only made for only one judge, correct? So in future, whenever you go for the litigation, you have to prepare the same number of, you see the compilation of the other side. Same thing you should give, whatever you rely upon, you should give it to the other side also, so that they can meet with whatever you want to say, correct?
Indeed.
Proceed.
The Council is appearing before the Honourable Court in the matter of Shuman versus Union of Cloud 9 and the Criminal Justice and Police Accountability versus Union of Cloud 9 on behalf of the respondent under Article 32 of the Constitution. If Your Lordships are well versed with the facts of the case, the Council seeks permission to proceed with the pleadings of the issue.
One question. You approach under Article 32. Could you not approach under Article 226 also? What is the difference between Article 226 and Article 32?
Your Lordship, under Article 226, any person can approach to the High Court for the violation of fundamental rights. While under Article 32, any person can approach the Supreme Court for
Then we know,
violation of fundamental rights.
correct? But the same thing you could have argued before the High Court also under Article 226.
Your Lordship, but here the
The
petition,
powers under 32 and 22(6) are different or same?
Your Lordship, but here the petition has been filed by the petitioners.
I mean, merely because you have filed approach the Supreme Court, that does not mean the Supreme Court will consider it. We are not on maintainability. Your on 32 will be maintainable, but the Supreme Court may not entertain also on the ground that you should go to the High Court under Article 226. There is a reason also why one should first normally Article 32 when the national issue and all important matters are all there, but when 226 same powers are available, correct? Sometimes 226 powers are even above also. Because Article 226, suppose you have approached and you have lost, you will give one right of appeal before the Supreme Court. But in 32 you have lost forever. So you will lose one opportunity of appeal before the Supreme Court. So whenever the client comes to you, correct, except you are practicing in Delhi, and if you are practicing in Gujarat or some other place, you should advise them, first we will go to the High Court under Article 226. Okay? Yes.
Indeed, Your Lordship, but here the issue is involving the law relating to the nation. So the High Court is not competent to address that.
Who says so High Court is not competent? Any High Court can declare the central legislature ultra vires. So far the territorial jurisdiction is only with respect to some the orders passed and the orders passed by the authority or the tribunal or the court. But so far the High Courts are concerned, so far the central legislation is concerned, correct? Even the state legislation also concern High Court. But central legislation, any High Court would have jurisdiction. Huh? That's a wrong conception that Article 226 was not the remedy available when it's a central legislation. Huh? Okay.
The Council seeks permission to proceed with the pleadings of the issue.
Yes.
Your Lordship, the first issue is whether the reverse honors clause drafted under section GG of Cloud 9 Vidhi Virudh Dharm Sam Parivartan Pratishedh Adhyades 2022 is constitutionally valid. It is most humbly submitted before the Honorable Bench that the reverse honors clause under section GG is constitutionally invalid, and the Council would be establishing this on 4 grounds. First, reverse honors passes the test laid down in the case of Sheikh Zahid Mukhtar vs. State of Maharashtra. Second, that it is for public interest and is judicially valid. Third, it does not violate fundamental rights and international covenants. And fourth, there are some other reasons for which reverse honors must be considered to be valid under this law. Proceeding with the first ground, Your Lordship, to determine the constitutionality of reverse honors clause crafted in section GG, it could be subjected to the fourfold test laid down by Honorable Justice Gupte in the case of Sheikh Zahid Mukhtar versus State of Maharashtra. Your Lordship, the first condition of the test requires the prosecution to establish certain basic foundational fact which must have a property connection with the presumed fact in a way that the latter is highly probable. The fact that a person has been converted itself acts as a foundational fact, because in a country like Cloud 9 where people have staunch belief in religion, conversion to another religion itself casts doubts about the same. That same could have been affected through misrepresentation, coercion, undue influence, or any other fraudulent means. Further, considering the marriage, the law is only applicable if the converting individual is not marrying under the Special Marriage Act of 1954. The Special Marriage Act 1954 states that any person can marry any person having different belonging to different personal laws can marry without changing their religion. And if only for the purpose of marriage a person is changing his religion, then it casts certain doubt that the marriage has been done for the purpose of unlawful conversion only. Therefore, the property connection with the foundational fact is established over here.
How there can be a presumption that because it is an inter-religion marriage, correct, and therefore it is doubtful?
Your Lordship, this is because
or because somebody, some parents or some they don't like, then what? Merely because it is an inter-religion marriage, by per se it can be said to be a doubtful marriage or suspicious marriage.
Your Lordship, but here, Special Marriage Act 1954, if person wants to, the only objective is to marry a person, then he can marry without changing his religion also under the Special Marriage Act. But here, if someone is converting the another person for marrying only, then it casts the doubts that the marriage was affected for the purpose of unlawful conversion.
No, but Cloud 9 is secular country. So if I want to change my religion, why are you presuming that because of marriage it got converted? I can convert my religion anytime, right? So what is that giving you a basis for this presumption? What is your basis for coming to this presumption?
Your Lordship, the right to convert is a fundamental right as guaranteed under Article 25 of the Constitution. But here, what the law says is that no other person must be given the right to convert another person. Therefore, the cases in which another person is converting a person, here it needs to be satisfied that it was done without using any unlawful thing.
Okay, please.
Your Lordships, may I draw the court's attention to the case of Noor Aga Khan versus State of Punjab, footnote number 9, in which the Honorable Supreme Court upheld the constitutionality of reverse honors, stating that presumption of innocence of presumption of guilt only arises when the prosecution proves certain basic foundational facts. And here, the basic foundational facts are clearly proved by the prosecution, and the property connection has been established.
What are the basic contents are proved?
That the conversion has taken place.
Conversion has taken place, per se it can be said to be a basic things proved.
Your Lordships, for reversal of burden of proof, the requirement is to prove the actus reus, and also that the actus reus is having a property connection with the mens rea. And here actus reus is the conversion, and the property connection which is established over here is that the person is not married under the Special Marriage Act, and also that the facts of the case clearly indicate that people in Cloud 9 have staunch belief in
So
the
your submission seems to be that without conversion also they could have married under the Special Marriage Act.
Indeed, Your Lord.
Correct? And therefore that the intention of the conduct of the party, correct, to get the other person converted and thereafter to marriage. Yeah? Therefore, first basic thing is established and proved, and therefore the onus is now shifted upon the accused to disprove it. No?
Indeed,
That is
Your
your
Lord.
submission.
Indeed, Your Lord. The second condition of the test inquires whether the aforementioned balance of fact involves a burden to prove the negative facts. Your Lordships, I would like to draw the attention of this court to the case of Anil Rishi versus Gurbaksh Singh, footnote number 10, and you may refer to the compendium R4. The Honorable Supreme Court proceeded on the basis that although generally it is for the plaintiff to prove fraud, undue influence or misrepresentation, but when a person is in fiduciary relationship with the other, and when the latter is in position of active confidence, the burden of proving the absence of fraud, misrepresentation or undue influence is upon the person who is in dominating position. And here the facts of the case clearly indicate that the person involved in converting or facilitating such conversion is in the dominating position or is in the fiduciary relationship with the person converted. Therefore, the reversal of burden of proof must be allowed over here. The third condition of the test requires that that reversal of burden of proof could only be allowed in the cases where certain special facts lies within the knowledge of the accused, as provided under section 106 of the Evidence Act. In the case in hand, after the prosecution has proved the actus reus, that the conversion has been done, and establishing the property connection, the element of mens rea is solely within the knowledge of the accused, as it is quite impossible for the prosecution to know what was the intent behind the conversion. Therefore, the reverse burden satisfies the third condition also. This leads us to the fourth condition of the test, which inquires whether in proving the innocence the accused is subjected to any hardships or operations. Your Lordships, in light of the difficulty of the prosecution to enter private spaces like offices, homes, to conduct search and seizures, the inconvenience of the prosecution often becomes greater in the case of criminal cases. While it is much easier for the accused having knowledge to prove his innocence without much hardships. In this respect, it is most humbly submitted before the Honorable Court that it is difficult for the prosecution to adduce evidence about the facts that lies especially within the knowledge of the accused. Therefore, it satisfies the fourth condition of the test also. Therefore, the reverse honest clause under section GG fulfills all the four conditions of the test as laid down by Honorable Justice Gupte in the case of Sheikh Zayed Mukhtar versus State of Maharashtra.
Now pause here for a moment. In future, whenever you go practice, correct, never use the name of the judge. You can say Honorable High Court or the Bombay High Court, correct, or Gujarat High Court, correct. Never use the name.
I apologize.
All of you. It's not in good taste at all. Correct?
I apologize.
You can say Honorable Gujarat High Court has said or the Bombay High Court has said this. Okay.
Proceeding with the second ground, that it is for public interest and is judicially valid. Under this, the first sub-ground is that it is for the public interest and has a deterrent effect. Your Lordship, the public interest combined with the magnitude of evil sought to be suppressed is the policy rationale that the Council advances over here. The recommendations of the 47th Report of Law Commission 1972 suggested that the injury to society was greater in certain offences against the public welfare, and unlawful conversion is one such offence. It was felt, therefore, that conformity with the traditional standard of proof impeded the state's efforts to prove the mental element that undoubtedly exists in the case of unlawful religious conversion, thus preventing the state from effectively addressing and regulating the problem of unlawful religious conversion. Reverse onus is an approach that attempts to achieve the goal of deterrence, which could contribute towards reducing the occurrences of unlawful conversions. The 47th Law Commission report suggested that there are certain crimes that gravely affect and harm the society, and so for such crimes it is necessary to dispense the burden of proof of the prosecution. The reversal of burden of proof brings a far greater decrease in the from the risk of erroneous acquittals. Reverse onus is made to deal with grave socio-economic offences that directly or indirectly harm the society. The burden of proof is generally shifted to gain conviction of the offences where deterrence considerations are greater. In that light, in the present case, the unlawful conversion is considered a grave social offence that affects the standards of morality in the society. And the deterrence to cruelty on account of conversion by misrepresentation, force, undue influence, coercion, fraudulent means or by marriage is justified. The second sub-ground under this is that it is judicially valid and is for judicial convenience. May I draw the court's attention to the case of P.N. Krishnalal and others versus Government of Kerala, footnote number 4, and you may refer to the compendium R5. The Honorable Supreme Court held that the presumption of innocence is not a constitutional guarantee and can be dispensed away by way of legislative imperatives or actions. Further, in the case of Noor Aga Khan versus State of Punjab, footnote number 9, the Honorable Supreme Court held that presumption of innocence may be a human right, but it cannot be equated with the fundamental right and liberty adumbrated under Article 21 of the Constitution. Although the presumption of innocence was required to be an element of personal liberty, the individual liberty must be subjected to the social interest to ensure security of the state. And here, in this case, the reverse onus clause was crafted for the purpose of social interest and to ensure the social security of the state. Thus, it must be considered valid. Closely upon the heels of Noor Aga Khan, the court in the case of Vinod Solanki versus Union of India, footnote number 6, and in the compendium R1, it was found well settled that presumption of innocence is only a human right and not a fundamental right. Now, may I draw the court's attention to the case of State of West Bengal versus Mohammad Omar, footnote number 7, in which it was held by the Honorable Supreme Court that traditional approach of of constantly placing the burden of proof on the prosecution when if it's only the accused of horrific crimes. When a prosecutor successfully establishes special facts of the case, the court must infer the existence and rely on such circumstances. In other words, after the court is satisfied with the prosecution's case, the burden of proof shifts to the accused, since only the accused is aware of every occurrence committed. It is submitted that another justification is the practical difficulty that is accrued by the prosecution while establishing the guilt of the accused. Your Lordships, it is difficult for the prosecution to adduce evidences about the matters that solely lies within the knowledge of the accused. Your Lordships, this justification also encompasses the rationalizations of judicial economy and administrative convenience, since reverse burdens appear to facilitate shorter, easier and less expensive trials, thereby conserving the valuable resources that would have ordinarily been expended in investigating the facts that are exclusively within the knowledge of the accused. The Council seeks permission to proceed with the third ground.
Yes.
The third ground is that it does not violate fundamental rights and international covenants. Under this, the first sub-ground is that it does not violate Article 14 of the Constitution. Your Lordships, the section GG of Cloud 9 Vidhi Viruddh Dharm Samparivartan Pratishedh Adhyadesh 2022 is not in violation of the Article 14 of the Constitution, because it is applicable to all the people and to the people of all the religion. Therefore, the allegation that it is against the interest of a particular community is vague and inadmissible. The second subground is that it does not violate Article 21 of the Constitution. Your Lordship, the Act aims to ensure that decision of individual to convert is theirs and theirs only. Since unlawful conversions strike at heart of personal autonomy and devalue the sense of identity and dignity of individual. Therefore, instead of violating Article 21 of the Constitution, the reverse onus clause is protecting their right. And contrary to the popular belief that the ordinance does not restrict a consenting adult from getting married to another consenting adult, provided they follow the circumstantial procedure laid down by it. The ordinance only provide under section YY that marriages that take place under unlawful circumstances are to be held void. Contesting the issue relating to the possible breach of privacy of individuals by regulating something as personal as marriage, it is most humbly submitted before the Honorable Court that while an individual's agency and capacity to love may unequivocally fall within the sphere of privacy, this does not mean that a welfare state should abdicate from its responsibility to ensure that such agency is not threatened by extraneous factors such as coercion, undue influence, allurement, fraudulent means or by marriage. Your Lordships, the Honorable Supreme Court in the case of Reverend Stanislaus versus State of Maharashtra, footnote number 15 and under compendium R2. The Honorable Supreme Court has established that if an attempt is made to raise communal passions, example on the ground that someone has been forcibly converted to another religion, it would in all probability give rise to apprehension of breach of public order affecting the community at large. The Apex Court in the same case also held that forceful conversion, if not prohibited, would lead to public order, and in order to prevent such breach of public order, the reverse onus crafted under section GG of Cloud 9 Vidhi Viruddh Dharm Samparivartan Pratishedh Adhyadesh 2022 is constitutionally valid. The third subground is that it does not violate Article 25 of the Constitution. Your Lordships, in the case of Reverend Stanislaus versus State of Madhya Pradesh, the Honorable Supreme Court held that upheld the constitutionality of the anti-conversion laws of Madhya Pradesh and the state of Odisha, and upheld the constitutionality of two laws and submitted that the reverse onus clause under section GG is not taking away anyone's right to freedom of religion under Article 25. Further, the Honorable Supreme Court in the case of Lily Thomas versus Union of India and Sarla Mudgal versus Union of India held that religious conversion carried out solely for the purpose of marriage and malafide intention do not pass the muster of legal scrutiny, and in order to keep a check on such malafide intention, the reverse onus clause must be allowed in this case. Fourth subground is that it does not violate international covenants. Your Lordships, it is important here to mention Article 14 of Universal Declaration of Human Rights, which says that every person has a right to convert. It says that every person has right to renounce one religion and convert to different religion. However, it does not provide a right to another person to convert another person. Therefore, it in no way infringes any of the international covenants. Therefore, it must be considered valid. Proceeding with the fourth ground, that there are other reasons for which reverse honest clause must be considered valid under the law. Conversion being one of the case that might not usually get reported due to fear of societal backlash or power asymmetry. The reverse honest clause is a solution that aids in coming to rescue of the victim and punishing the accused. There are no fetters which have been placed under the Act to take away the freedom of conscience of the individual, and the individual is only required to follow the procedure established by law while exercising the liberty to change the belief and faith. There is a compelling state interest in preventing the disproportionate forcible conversion over here, as forcible conversions strike at heart of personal autonomy and individual agency. It is most humbly submitted before the Honorable Court that when marriage is one of the instruments being abused for unlawfully converting individuals, the state cannot abdicate its responsibility to regulate the alliance of two adults. To love is to live better, but the agency of an individual to love cannot be eroded by exercising undue influence on them and forcibly converting them to a different religion under the garb of better lifestyle. Your Lordship, the institution of marriage forms the bedrock of any individual's most profound hopes and aspirations. To discount such an institution and use it as a sole instrument for conversion goes against the very ideals of our constitution, which is premised on the idea of individual autonomy. Therefore, the reverse honest clause crafted under section GG of Cloud 9 Vidhi Virudh Dharm Parivartan Pratishedh Adhyadesh 2022 must be considered valid.
One question. Nobody can dispute that this rule of reverse proof is an exception to general rule. Correct? The general rule is that onus is first upon the person who alleges, and thereafter the burden shifts upon the other side. Correct? What do you say on exception to the general rule?
Your Lordship, reversal of burden of proof has certain requirements, and here section GG fulfills all the requirements. That the prosecution has already established the foundational facts, has established the probability connection with the presumed fact that the accused is trying to convert the person unlawfully. Therefore, the reversal of burden of proof must be allowed in this case.
You can very well argue. Just very complex, I think. That this is a special act. Special act for a special purpose and with a special object and purpose. Correct? Therefore, correct, this can be an exception to the general rule to achieve a particular object and purpose. It is permissible under the law. That should be your submission.
Indeed, Your Lordship. It was for public interest.
Because not only public interest, it was for public interest and to achieve a particular object and purpose, having realized after the law commission report and everything that this is being misused. This is for a purpose. The conversion is only for a particular purpose. So to curb that, correct, the particular act, special act is established and put. Therefore, it can be exception to the general rule. When special act is there, correct, the special procedure is always permissible. Thank you.
Your Lordship, now the co-counsel would be dealing with the second issue.
You are Abhay. Okay.
The counsel seek permission to proceed to the facts.
Yeah.
The Lordship, the counsel seek permission to produce with the pleading of second issue. Much obliged. The second issue is whether the direction passed to reveal passwords of personal electronic possession in the light of Article 20, Clause 3 are valid. It is most humbly submitted before the Honorable Court that the direction passed to reveal password of personal electronic possessions in the light of Article 20, Clause 3 are valid. Your Lordships, petitioner mentioned about 3 conditions, in which one was that there should be compulsion to use Article 20 Clause 3. According to the facts given, the police never compelled Shuman to give testimony against himself. They just asked for a password, not for the testimony. They only need the password to the device, which is also available under various sections of CRPC. So the argument given by petitioner on the Article 20 Clause 3 are now invalid, as the same condition set by them is not satisfied according to the fact. Section 91 of CRPC summons to produce document or other thing. Whenever any court or any officer in charge of a police station consider that the production of any document or other thing is necessary, desirable for purpose of any investigation inquiry, the court may summon to produce such document, and I will prove that a mobile phone is treated as a document, because according to Section 65B of Indian Evidence Act, admissibility of electronic records, any information contained in an electronic record which is printed on paper, stored, recorded or copied in optical or magnetic media produced by the computer shall be deemed to be also a document. Your Lordship, the password and mobile phone are like a key and a box. A password also, like key, a password also is not self-incriminatory. On opening of box or unlocking of mobile phone, something non-incriminatory and something may be such which may help in discovering the element fact may be found. Only incriminatory thing would violate clause 3 of Article 20, and that will not be admissible in the evidence. Then investigating agencies are concerned with such things and which are helpful in discovering relevant fact, it would not violate clause 3 of Article 20. Your Lordship, as I mentioned about Section 91 CRPC, to the accused to produce a document which would include a smartphone, laptop, etc. Similarly, Section 93 permits the court to issue warrants to a place. These provisions empower the search and seizure of things from a place, and smartphone, computer, servers, etc. may be constructed as place for this purpose of this section. In emergent circumstances, power under Section 102 CRPC may also be exercised by the investigation officer to seize electronic equipment. All said and done, the decision is a crucial one. Indeed, there may be privacy related concerns when it comes to a smartphone, laptop, etc. But a narrowly tailored right with the investigators to seek such information is need of the hour. Therefore, the direction passed to reveal password of personal electronic possession in the light of Article 20 Clause 3 are valid, as we discussed that it is the part of investigation within the right of the accused. There is no violation of Article 20 Clause 3 because there is no compulsion when a police officer in investigating a crime against a certain individual asks him to do certain things. Your Lordship, I like to quote a case where the Supreme Court in the case of State of Bombay versus Kartik Aliogar held that there is no compulsion when a police officer in investigating a crime against a certain individual asks him to do certain things. The fact that a person was in police custody when he made the statement is not a foundation for an interfere that he is compelled to make the statement. The mere question of accused by a police officer resulting in voluntary statement which may ultimately turn out to be incriminatory is not compulsion. Your Lordship, due to scientific developments, very sophisticated and modern techniques have been developed which are being used by the criminals nowadays. Due to traditional methods of our law and investigating agencies, we are lagging behind the criminals. So for use of such techniques are concerned, therefore it is need of the hour to allow new method of investigation in do complete justice to the victim and public at large. In the present matter, the petitioner is trying to stop the wheel of the justice in the name of individual right. At the cost of justice to victim, a public at large, no right is absolute. Right are always subject to reasonable restriction. So in case of Article 20 Clause 3. Now I would like to state the case of Dinesh Dalmia versus State. The court observed that where the accused has not allegedly come forward with the truth, the scientific tests are resorted by the investigating agency. Such a course does not amount to testimony compulsion, as no accused will be will give the consent to give the polygraph test for himself and will not.
Don't say what we have said. It's a great advocacy. It is said, know thy judges, and saw what the judge likes. Thank you. Good advocacy.
From the above discussion, it is very evident that conducting a polygraph test does not violate Article 20, Clause 3 per se. Thus, there is no reason why we should prohibit a test on ground of unconstitutionally, and there is no reason to discuss these things for long hours, because these are the case that should be completed within some hours, because there is no compulsion at all. As petitioner said that there is compulsion and Article 20 Clause 3 should be applied, but they have not read the fact that the police never compelled Shuman to give testimony against himself. They just asked for a simple password which is not amount to a testimony. So Article 20 Clause 3 is not admissible right here.
Have you considered Section 69 of Information Technology?
Pardon, Lord, I need to look upon that issue. I have not considered that.
Okay, no problem. Please proceed.
So if judges are satisfied, I would like to proceed for the prayer.
What do you say on the judgments or the decisions cited by them, correct, on polygraphy test, and the Honorable Supreme Court say that it is not permissible, it is violatory Article 21. What do you say on that?
It is the violation of Article 21 of privacy, but we are not conducting polygraph test for
Not privacy only, correct? Nobody, it is Article 12, so Honorable Supreme Court also stated it is violatory Article 23 also, because to say something against yourself, correct, to compel you to say something, give witness against you, correct, it is violatory of Article 23, and there are some judgments which are cited, correct. What do you say on that?
Honorable Lordship, I would like to say that the police is trying to conduct polygraph test for the password only, not for any type of testimonies, not for any type of compulsion, not for anything. They just want the passwords, as Shuman, as the fact of the case clearly indicated that Shuman was caught among the protesters, creating disturbance and breaching the public order. Then it might be possible that Shuman was one who instigated the public to protest, and it is like issue of public disorder. It is very necessary to check the phone of that accused. So we need just the password, and for that we are conducting the polygraph test, not for any type of statement or any type of confession from him.
Are you saying that it is in aid of investigation?
Yes, Your
You
Honor.
want to do it? Is it
Yes.
permissible to do it in aid of investigation?
Or under the garb of or investigation, in furtherance of investigation?
Yes, Your Lordship. As sorry, Your Lordship, I need to look upon that issue because I have not read through that thing, because I don't think that investigation, because there are, as I said, that today there have been very sophisticated and modern techniques that are being adopted by criminals, but the traditional methods of the laws were trying to stop and will help the criminals.
We got a conclusion.
So prayer. Wherefore, in the light of issue raised, argument advanced, and authority cited, it is humbly prayed that the Honorable Court to dismiss the plea of the petitioner, to declare reverse honors clause in section GG of Cloud 9 Vidhi Viruddh Dharm Samparivartan Pratishedh Adhyadesh 2022 constitutionally valid, to declare the direction passed to reveal password of personal electronic possession in the light of Article 20 Clause 3 as valid. To all of which is humbly prayed, counsel for the respondent.
It might be possible, nowhere mentioned that he was involved in the
The council seeks permission to approach the guy for rehearsal.
You want to say something in rejoinder or reply? Do you want to make submission on some or their submissions? Come on the dais.
Much obliged, Honorable Bench. This first argument that has been placed by the council from the side of respondent is being the basic first test of establishing the basic foundational facts has been satisfied by the state of Cloud9. Honorable Bench, this whole argument is completely immoral and is baseless. Mere stating the fact that conversion has been happened, and by this fact the burden of proof will be shifted to the accused is completely immoral, because there can be the cases where a victim with the whole consent has converted and want to convert her religion. So mere stating conversion happened and then establishing the fact the basic standards or the basic essentials has been proved by the state of Cloud9 is completely baseless and is immoral also. Second rebuttal which I want to give on their argument is presumption. When the client from the side respondent comes and say that Article 25 allows right to profess, propagate religion, but if you are converting your if someone is converting their religion by a marriage, it is an itself established fact. Now, Your Lordship, Honorable Bench, through various case studies and also these laws has been implemented in 8 states of India, Honorable Bench. In these cases, there are very cases where conversion has been done with the consent. Now, if the family is against the marriage, and also the loophole in section PP, if the family is against the marriage, even if the consent has been done,
try to appreciate one thing. According to you, according to the accused, it was by consent, correct?
Yes.
You establish and prove it that it was by consent.
Your
Now
Lordship.
that onus is upon you thereafter to prove that it was by consent.
Yes, Your Lordship. To this,
We are on the initial stage of the burden.
Your Lordship, the counsel from the side of petitioner is saying at first it was the duty of state to prove the basic
No, we are on
foundational
your
facts.
subpoena. It was by consent. Consent, okay, you prove it by consent.
Your Lordship, it will be very difficult for accused to prove the consent, Your
Why?
Lordship.
Victim, the girl, correct? She will be in the witness box.
Your
She will be
Lord-
subjected to cross-examination.
Your Lordship, for this I would like to refer to the anti-religious conversion laws which have been implemented in many states of India, Your Lordship. Your Lordship, what happens if if the parents are against the marriage, they file an FIR and the accused go to jail, Your Lordship. Now it is the basic, Your Lordship, now the basic thing of filing an FIR and making the accused guilty, which is violating Article 21. Why a person should be guilty even if without establishing why a person should be guilty without establishing or given a proper chance to present fact in his own favor, Your Lordship. Coming to the third rebuttal is regarding the case law which they implemented, which they put forward to, is Anil Rishikesh versus it says that in every misrepresentation, undue influence, and everything which happens if religious conversion is happening with these things like misrepresentation, undue influence, it will be void. The council do believe that if the conversion is happened forcefully or illegally, it should be void. But, Your Lordship, the council seeks attention on the word allurement, Your Lordship. It is very subjective and very unthinkable. The council seeks permission for some time extension. It is very unthinkable and it is very difficult for accused to prove that the prosecution was not allured with my specific terms, Your Lordship. So when they come up, when the client from the side respondent gives that the subjectiveness and the negative fact has been proved, they failed to give me the answer of the term. What they failed to justify me the answer regarding the term allurement. How the accused will prove that no allurement has been happened from the side accused, and how the prosecution will deny clarify that I was not allured with the specific contention, Your Lordship. Thank you so much. All blessed.
You want to say something? Yeah, come.
Your Lordship, the first rebuttal from the petitioners was regarding basic foundational fact. And here the prosecution has already established the basic foundational fact, which is the prerequisite for presumption of guilt of the accused. Once the actus reus is satisfied and probability connection is established, then it is upon the accused to prove that the same was done without that the conversion was not done unlawfully. And second is the right to convert under Article 25. Your Lordship, Article 25 gives right to the person himself that he can convert himself, and not this right is not available for other person that you can convert any other person. Therefore, this both the rebuttals are inadmissible. And also, P.N. Krishna Lal case, in which it was held that the burden of proof, reversal of burden of proof can only be allowed in those cases where the accused is not required to prove the negative facts. This case was of year 1995, and the Anil Rishi versus Gurbakh Singh, the case cited by the respondent is of year 2006. Therefore, it is valid over here that Anil Rishi versus Gurbakh Singh must be considered. That
Supposing the subsequent decision, earlier decision is not considered then,
Your
or taken
Lordship,
note of then, which will be binding.
but here, Your Lordship, in Anil Rishi versus Gurbakh Singh, it was held by the Honorable Supreme Court that
Suppose in a given case it may happen, correct? That earlier decision was not cited or not brought to the notice in the subsequent decision, correct? Then what do you say? Any
Your Lordship,
particular word is used for that?
Your Lordship, but here
Can it be said that subsequent decision is binding?
Your Lordship,
Because there cannot be any presumption that earlier decision might have been considered. So one has to consider the facts whether in fact the earlier decision was considered or not. Suppose earlier decision is not considered in the subsequent decision, correct? Then what can be said to is that subsequent decision is per inquirium. The proper word is per inquirium, correct? Then for the subsequent bench can take a another view also. Or you can very well argue that the subsequent decision is by a higher number of judges.
and Your Lordship, in the case of Anil Rishi versus Gurbakh Singh, it was held by the Honorable Supreme Court that when two parties are in fiduciary relationship with each other, and also where the one party is in dominant position than the other party, then the facts that the same was that there was no undue influence, coercion or allurement exercise must lies upon the party who is in dominant position or is in the fiduciary relationship.
That you already argued earlier. You are in rebuttal.
Yes.
Rebuttal is not repetition.
Your Lordship, I'm repeating the same because it was.
Because they have repeated, I am repeating.
I'm only
Just not a lighter
answering
side.
the rebuttals only.
Yeah, we are in just lighter side. Because serious is very serious. Matter, subject is very serious. Therefore, you have to be very lighter. You have to keep the atmosphere very lighter. Anything you want to say? Any further rebuttal?
Your Lordship, the petitioners pleaded that Shuman had not consented for giving passwords, but the facts of the case clearly prove the point that Shuman complied with the directions of the trial court. But the contention over here is that what password he gave was wrong. Therefore, the polygraph test was allowed by trial court. Second, the law does not violate Article 14 of the Constitution. This is because it is applicable to people of all the religion.
So your supposition is that his conduct, correct, of giving false password led to the court to pass a subsequent order of polygraph.
Indeed, Your Lordship.
No? Because he made a false statement, correct, and gave incorrect password,
Indeed, Your Lordship.
which led to the court, correct, of holding having a presumption against the summon and pass an order of. So in the facts and circumstances of the case, according to you, correct? The Honorable Court was justified in passing the order. Indeed. If you would have given or not given at all, it's a different thing. Suppose in a given case, correct? Even if their submission is accepted, polygraph is not permissible and everything, correct? If you would have not given password, then okay. But once he has given and it was found to be wrong, correct? In that case, correct, there is a solid presumption against him, correct, that he has suppressed the material fact, and to find out the truth, correct, the polygraph was allowed.
Indeed, Your Lordship.
Just we want to know only one thing, correct? All of you, correct? Who prepared your notes? Who prepared your submissions and notes? You also? Yourself? Sure? Polygraph test is not needed, no? Huh? We are really impressed here.
From first year it is really.
Not even first year. I don't want to say anything. Really? Amazing. Even these type of submissions, I am coming at present Supreme Court judge, correct? Even Supreme Court also, these are submissions of Supreme Court. You deserve Congress, whether you succeed, whether you win or not, it's a different thing. Just I was a little bit that who prepared, you yourself prepared all these things. You found out the judgments.
Yes.
Your all submissions.
Yes.
No legal advocate, no advocate test.
No legal advocate.
Ketan bhai, whatever it may be result, all 4, 6 special prize to apanu. Really amazing. Okay, we'll come here.
All rise.
All of you are requested to be seated at your place. All of you, please remain seated at your places.
What do you think you have both the I told कंफर्ट करने की कोशिश अच्छा
नहीं सही है भाई सही
है तो पहले कोई नहीं बैठा वही
How was it? I really want to win this.
Let's we should not cry. We can feel other part of
जो 3 कंडीशन है वही सेटिस्फाई
तो 40 साल तो 12.5 साल 13
Because of the legal questions का answer that we gave.
अच्छा ये सब ऐसे बोलना नहीं आ रहा थोड़ा मोटा था भैया लाइफ लाइन में चली गई भाई, ये तो देख ली भाई। इसको भाई सुबह जब पॉइंट लिखवाया था मैंने, CRP और एविडेंस बैंक लिखवाया था सुबह।
एक रुपये बचेगा ठीक है,
ऐसे देखिए
शाम को देंगे, शाम को
बात करूँगा
वो रिपीट कर रहा है।